Hi everyone, I am Suyash and today I will talk about the case of Ellora Paper Mills Ltd versus State of Madhya Pradesh, wherein the Hon'ble Supreme Court discussed Section 12 subsection 5 of the Arbitration and Conciliation Act, that is a non-obstante clause providing for the ineligibility criteria for appointment of an arbitrator. Section 12 subsection 5 states that notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in the 7th schedule shall be ineligible to be appointed as an arbitrator, provided that parties may, subsequent to disputes having arisen between them, waive the applicability of this subsection by an express agreement in writing. Basically, Section 12 talks about 7th schedule of the Arbitration Act that provides for the relationships that makes a person ineligible to be appointed as an arbitrator. Some of the key relationships are A. Employer-employee relationship, B. Client-attorney relationship, C. Close family relationship, D. Advisory relationship, E. Part of same management, F. Significant financial interest involved of the arbitrator in the case, G. Previous involvement of the arbitrator in the case, and H. Any direct or indirect interest in the dispute. Hence, if there exists any of the above stated relationships, then such person shall be ineligible to be appointed as an arbitrator. Further, Section 12 subsection 5 also has a proviso that stipulates that the parties, after arising of the dispute, by way of an express written agreement, may waive off such ineligibility criteria and appoint any person of their choice to arbitrate over a dispute. In the present case, the court explained that Section 12 subsection 5 was amended to provide for legal provisions governing the neutrality of arbitrators. According to the court, if Section 12 subsection 5 is attracted in a particular case, then in such a situation, the appointment of the arbitrator would be beyond the pale of the arbitration agreement, empowering the court to appoint such an arbitrator as may be permissible. Essentially, independence and impartiality of the arbitrator are the hallmarks of any arbitration proceedings. Rule against bias is one of the fundamental principles of natural justice which apply to all judicial and quasi-judicial proceedings. It is to be understood that even when an arbitrator is appointed in terms of contract and by the parties to the contract, he is independent of the parties. What is to be noted is that Section 12 subsection 5 is a non-obstante clause and has an overriding effect on the prior intention and agreement of the parties. Though party autonomy is an important principle followed in the field of arbitration, yet equally important are the principles of impartiality and independence of the arbitrators. The concept of party autonomy cannot be stretched to a point where it negates the very basis of having impartial and independent adjudicators for resolution of disputes. In fact, when the party appointing an adjudicator is the state, the duty to appoint an impartial and independent adjudicator is that much more onerous, and the right to natural justice cannot be said to have been waived only on the basis of a prior agreement between the parties at the time of the contract and before arising of the disputes. If parties to an arbitrable dispute wish to waive off the applicability of Section 12 subsection 5, then there must be an express agreement in writing to satisfy the requirements of Section 12 subsection 5 proviso. Thus, in conclusion, following important points emerge. A. Section 12 subsection 5 is a non-obstante clause having an overriding effect on the prior intention and agreement of the parties. B. As per Section 12 subsection 5, an arbitrator is ineligible to be appointed if he has certain types of relationships with the parties or interest in the subject matter of the dispute. C. After arising of the dispute, The parties may waive off the condition is stipulated in section 12 subsection 5 by way of an express written agreement. And D. The purpose of section 12 subsection 5 is to ensure neutrality, impartiality, and independence of arbitrators. Thus, I hope that the mandate and the scope of section 12 subsection 5 of the Arbitration Act is clear by now. Hence, I hope you enjoyed listening to the show. Thank you for listening. Please do not forget to like, subscribe, and comment. See you next time. Till then, stay tuned.